Good day everyone. For this video, we are going to discuss about the crime of violation of domicile. This is defined and penalized in Article 1 to 8 of the Revised Penal Code. Again, we have our usual disclaimer. Article 1 to 8, violation of domicile. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or having surreptitiously entered said dwelling and being required to leave the premises shall refuse to do so. If the offense be committed in the nighttime, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prison correctional in its medium and maximum periods. So as usual, let us dissect this article. There are three punishable acts of violation of domicile. They are, number 1, the public officer enters any dwelling against the will of the owner. Number 2, the public officer searches papers or other effects found therein without the previous consent of such owner. Or number 3, having surreptitiously entered said dwelling and being required to leave the premises, the public officer refuses to do so. Remember that the term public officer here must be vested with authority to make an arrest or conduct a search. So it has a similar definition as the public officers mentioned in Articles 1 to 4, 1 to 5, and 1 to 6. So examples are police officers, NBI agents, and PDEA operatives or other law enforcement agents. Other public officers or private individuals, they are lumped together under one category, who enter the dwelling of another against the latter's will be liable for another crime. The crime is trespass to dwelling in Article 280 and not for violation of domicile. Now, what are the elements common to the three punishable acts? There are two. Number 1, that the offender must be a public officer. Again, the public officer here refers to a public officer who is vested with the authority to effect an arrest or conduct a search, like policemen. And second, which is the most important element, the public officer is not authorized by judicial order to enter the dwelling of another person and or make a search therein for papers and other effects. This is the element that will constitute a violation of Article 1 to 8. Why? Because even if the offender, even if the public officer concerned is authorized by law to effect a search or conduct a search, if at the time of the entrance he is not authorized by a court order to enter such dwelling and or make a search therein for papers and other effects, he thereby commits a violation under this article. The authority here I am referring to is called search warrant. Okay, and search warrant as defined in Rule 1 to 6, Section 1, is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and to bring it before the court. Now, why would a police officer apply for a search warrant or why would a court issue a search warrant? A police officer would apply for a search warrant because he would be searching for personal property subject of an offense, like for example, firearms which are not licensed. Or the police officer would like to search for property which is stolen or embezzled, or properties which are fruits of the offense. Or the police officer would like to search for properties used or intended to be used as means of committing an offense. Those are the properties that are the subject of a search warrant. And that is the reason why a police officer applies for a search warrant, and that is also the reason why the court, if there is probable cause to issue a search warrant, would give authorization to the police officer concerned to enter the dwelling of another and make a search therein for such properties. Now, let's go to the first punishable act. What is that first punishable act? The public officer enters any dwelling against the will of the owner. Take note of the underscored portions. When you say dwelling, it means a house, an apartment, a room, or other structure devoted for rest and comfort. It can also be a building where a person resides. And when you say against the will, it means there must be a prohibition or opposition to enter, whether such prohibition is expressed or implied. Implied meaning, for example, when the door is closed, even if not locked. And if the offender entered merely without the consent of the owner, the crime is not committed because lack of permission should not be confused with prohibition. For example, at the time X, a policeman, entered Y's dwelling, the door was already opened and no one was inside the house. Here, the entrance was clearly without Y's consent, but just the same, it will not constitute a violation of domicile. Why? Why do you think so? In the example, because the door was already opened at the time X arrived in Y's house or in Y's dwelling. So there was no implied prohibition or presumed prohibition to enter because the door was not closed, the door was open. The law only requires the door to be closed. It doesn't require that the door should be locked. But if the door is already open at the time of the entrance, then there is no violation because the rule requires that there must be at the very least a presumed or implied prohibition to enter. What about the word owner? While Article 128 specifically uses the word owner, it is submitted that the same should include any person who has a right of possession over the property, like a lessee of an apartment or a boarder of a room. The reason here is that their right to privacy and or their right against unreasonable searches and seizures must be respected even if they are not owners of the dwelling place. A member of the household who is of sufficient discretion is an extension of the owner. The word household here refers to the immediate members of the family or the occupants of the house. For example, X, daughter of Y, the owner, tried to prohibit but to no avail Z, a policeman, from entering the house. At that time, Y was not around. The crime of violation of domicile here is committed. Second example, X, a daughter of Y, the owner, allowed Z, a policeman, to enter the house. At that time, Y was not around. Here, the right to privacy is deemed waived. The crime of violation of domicile is not committed. Third example, X, daughter of Y, the owner, allowed Z, a policeman, to enter the house. At that time, Y was not around. It was only when Y arrived that the latter asked Z to leave the house, but Z refused. Question, is there a violation of domicile? The answer is no. Permission to enter was already given by X. The refusal to leave will only constitute the crime of unjust vexation under the second paragraph of Article 287. Now, in all these three examples, it is shown here that X, being the daughter of Y, is a member of Y's immediate family and household. And as such, X should be considered as the extension of the owner Y, and her refusal in the first example, or her permission, or the permission she gave to Z to enter their house, should be regarded as or considered as valid and effective, because X here is a person who is of sufficient discretion either to allow the public officer to enter the dwelling or to prohibit the public officer concerned to enter the dwelling owned by her father Y. Second punishable act, that the public officer searches papers or other effects found therein without the previous consent of such owner. Again, take note of the underscored portions. This second punishable act contemplates of a situation where the public officer was allowed entrance, but the search of papers and effects was without the owner's consent. Example, X allowed Z, a policeman, to enter his house. Z started to search the house to look for the gun allegedly used by X's son in shooting his neighbor Y. X did not stop Z from searching. Here, there is no violation of domicile because this is akin to a consented search. The search contemplated in the second punishable act must be a physical search, not just a visual search. The papers or other effects referred to in the second punishable act, take note, must be found inside the dwelling, not outside. Third punishable act, having surreptitiously entered said dwelling and being required to leave the premises, the public officer refuses to do so. The word surreptitious means to keep secret, especially because it will not be approved of if discovered. What is punished here is the refusal of the public officer to leave the premises after being required to do so, not the surreptitious entrance. And in the second paragraph of Article 128, we have this provision where the crime of violation of domicile becomes qualified. And how does it become qualified? It becomes qualified when, number one, the offense is committed in the nighttime, or number two, if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender. So these are the two instances. The existence of one instance will already qualify the crime. And when I say qualify the crime, it will increase the penalty from prison correctional minimum, which is the penalty imposable for simple violation of domicile, to prison correctional medium and maximum, which is now the penalty for qualified violation of domicile.